Okay, we are going to start with a prayer, and I have requested one of my classmates, Monica Loco. Greg, please pass the mic to. Okay.
Good evening, everyone. Let's pray. Everlasting Father, Lord of Lords, King of Kings, we bow before your presence. Thank you because of this precious time through given to each and every one of us. We rejoice and glad because of your holy name. We invite you, dear God, as we begin this webinar, oh God. We pray that you're going to be present. You're going to be here with us. You're going to guide us. I dedicate our lead discussants unto thee, oh God. Be there for them. Bless them, O King of Glory. I dedicate each and everyone else who is joining physically and also online. Through may also bless them and give them understanding, oh God. Thank you for your wonderful and amazing. As we shall see the end of this webinar, all the honor and the glory shall be back into you. In thy name, I do pray, the trusting and believing. Amen.
Okay, good evening, good afternoon, good morning. Greetings to everyone who's joining us. Welcome to the third Avid Readers Forum discussion series where we are commemorating Katiba, that's Constitution of Kenya 2010, that's turning 15 years, so it's Katiba at 15. This session is about third generation rights. If you go on our YouTube channel at Kabrak Law School, you'll be able to see the second episode, which was on second generation rights, and a few weeks back on first generation rights. And we are so grateful to the panelists, the lead discussants, that's Eva Zogada for the first, and Senior Counsel Charles Kanjama for the second episode. And now we have an esteemed panel here today. My task is very simple. It's just to relay gratitude from the co-coordinators of the Avid Readers Forum who could not be here with us today. That is Mr. Cedric Kadima, Mr. Ongoya as well, and Ruth, although Ruth is in the room with us, so she will give her vote of thanks. Mine is just to be that face for protocol. My name is Melissa Mungai and I teach at the law school. So without any further ado, I'd like to pass the mic to our most able moderator for this event, Carson Kiburo, to start off the discussion. Thank you, Carson.
Thank you so much, Miss Melissa. We now go directly into our event. Once again, good afternoon, everyone. You are here with us online, but we are here at Kabarak Law School at Sawia Auditorium. Welcome to the Avid Readers Forum. Today, we mark 15 years of transformative constitution that we gave it to ourselves as Kenyans in 2010. And we're exploring that generation collective and solidarity rights. We will try as much as possible to not to speak legal language, because we also have a community tuned in, not just lawyers. Yes, so my name is Carson Kiburo. I'm a student at Kabarak University Law School. When I'm not at Kabarak University Law School, I am also an indigenous rights advocate, not advocate as in lawyer. And I collaborate with grassroots movements, including Ogiek People's Development Program, Jamia Celia Center, and so many others on litigation strategy and community protocols. For today, I step back from that advocacy space just to serve as a neutral facilitator, away just like my lecturer here, away from this space, so that we can interrogate these collective rights, jurisprudence with clarity and honesty. Why is this conversation important today? So Kenya's Bill of Rights did more than guarantee individual dignity. It also constitutionalized community interests, environmental stewardship, and intergenerational justice, as we see in the preamble of the Constitution and Article 42 or 56 and 69. So 15 years on, the jurisprudence from the Ogiek and Roy's and recent climate change petitions shows that both progress and persisting fault lines. But that is not what I am going to talk about. I do have panelists here with us, and we're very grateful for giving us your time to share your knowledge on what I have just talked about. So the first person that I wanted to introduce to you, my panelists. The first person that I have here is, allow me just to pull up so that I don't say my own things. So we have Mr. Donald Dare, who is the Chief Executive Officer, Pan-African Lawyers Union, or PALU. He's also the chair of Pan-African Citizens Network, board chair, International Coalition for the responsibility to protect. He's also an advocate of the High Court of Kenya, over 20 years in practice, regional public interest litigation, has been at the East African Law Society as a CEO, and so much more. We also have Ms. Sorry, I'll just go on. I assume that we don't have tag names, but we already have their names on Zoom, as you can see. We also have Emily Kinama. She's the head of strategic litigation at Katiba Institute. And also she's an advocate of the High Court of Kenya. She's a legal scholar as well with masters in law. And she's been doing cases on digital ID, land and urban planning, forest communities. Like, for instance, I know she has worked with some of us who are here. Last but not least is Mr. Daniel Kobe, founder and executive director of Ogiek People's Development Program. He's also the representative to the International Indigenous Forum on Biodiversity under the CBD, or United Nations Convention on Biological Diversity. He's an indigenous human rights defender who steered the Ogiek community's 2017 victory at the African Court on Human and People's Rights, drives Mau forest restoration via community stewardship, mentors indigenous movements across Africa. And it's an honor to have all of you. Mr. Ogiek, thank you so much for your mentorship to some of us, including myself. Well, let's go directly into the event. So maybe I should start with the community, or let me start with Mr. Dare. Hold on, I'm just pulling my questions. Sorry.
Actually, don't mind you starting with the community, so that we center the community first. Then those of us who are trying to support the community can follow.
Great, thank you so much. Fantastic. So we are going to start off with Mr. Daniel Kobe, as I have introduced him. Mr. Kobe, please tell us about your, based on what we've talked about. I've introduced you on litigation on indigenous rights and the long struggle of the Ogiek people. Based on what we're discussing today, which is third generation rights, and how has that journey been? And from the perspective of somebody who has litigated locally and out of Kenya, you have 10 minutes. Thank you so much.
Good afternoon, good evening. First, thank you very much for the honor, Donda, Emily, for allowing me. I always wish I could hear from you first. But as you say, it's good to start with the community. I always like telling stories about the journey of the community. I may not follow the order you have put the questions, but I always wish you could understand first what is a struggle for a community. And first, Ogiek as a community, or as a representative of many communities, we are historically hunters and gatherers, and we are based found in Mau Forest Complex and also in Monelgo. So as a community, first we started with marginalization or or rather a situation whereby we were not recognized as a community. The struggle for some of us have taken over 20 years. In fact, my first work for the community is 1995. So when I started in 1995, we were young men by then. We were trying to see and say, why are people calling us the robots and not Ogiek? So the first thing was to identify ourselves and begin to make people know who we are. We fought that, and with the support of media, the people begin to say, oh, the Ogiek, we call ourselves Ogiek, but not the robots. So we managed that. And then also, after that, we realized we had other challenges. One was land rights. So as a community, we realized that we didn't get land like reserves, what they used to call reserve by then, by the colonial government. We started now saying we need our rights. By then, there were people also, the community who were facing evictions in other areas, especially in the eastern part of Mao. So we started now the issue of saying, no, we need our land. So by then we got our land rights. We got a chance to speak. Then by then, President Moi, who happened also to be the founder of Kabarak, said, well, let's give Ogiek a piece of land within Mao. And then immediately we found many others coming in, other communities coming in and taking up the same land. That's what led to the Ogiek going to the High Court here in Kenya for almost 12 years. And then because we found that we were not getting what we wanted. And as a community, we were saying we needed our land rights. We needed things the way we wanted. But we were being forced to get, like, you wanted to get 5 acres of land. As you say, we needed our community land. So as we struggled, it took us years and years. I remember court issues in Kenya, where you are told
Mr. Kobe, this is Carson on a second device. I am so sorry, but we lost you for the last few minutes because we had a technical hitch over here. Maybe you can go back a few, like 3 minutes into, and I'm so sorry that we're asking you to go back again. My apologies. Or 2 minutes back.
The problem when you are telling stories, you don't have notes to refer to. So I'll try my best. I was saying that when we started as a community, one of the issues was recognition, to be known as a community, to be identified. And then later we realized the community were facing other challenges, including land. So because the Ogiek were having, they were not having, they didn't get land rights. Remember, if you go back, for those of you who have read about the Ogiek, there's a time there was a recommendation from the Kata Commission that Ogiek should be assimilated and some of them be taken to Bomet and other areas. So we started now fighting for those land rights, which led even when Moi said, let's give Ogiek a piece of land in Eastern Mao. The community said, but you are not giving us land, you are bringing other communities to take over the Ogiek land, which later on now we realized that there was need for us to go to court. So we went to court here in Kenya for a period of almost 12 years, and we realized nothing was happening. And 2009, there was a call by Kenya Forest Service that the Ogiek should be, everybody in Mao should be evicted. And that is when we realized there was need for us to go to seek other legal redress, as when we went to the African Commission on Human and People's Rights in Banjul, the Gambia. And we placed our case before the commission. By then, we were following the steps of the Android people, and we thought that was the best way to deal with the Ogiek issue. So then we started realizing that the commission found that there was a lot of mass violations of the Ogiek issue. That's when they decided in 2012 to transfer the case to the African court. I know Don can be able to tell more stories about that after this. And in all this, we realized the need of unity of the community to fight for their rights, their land rights. And one of the issues we asked for was community land or restitution of our land. And it took long, of course, being in the almost 8 years in the African court and the commission. Then by then, one issue which I will let you know is that we worked as a community collectively, asking and creating that connectivity with the community. I always say one strength we got was a fit about what is happening in court and what is happening, all the legal letters from the court, from the commission, because the commission stood on behalf of the Ogiek community. And as a founder of Ogiek People's Development Program, our work was to facilitate the community, to work closely with the community, have meetings with men and women. And later on, we realized there was a big need to have the youths, which now you could see what's happening in Kenya now. There was need to have the youths. One time I was asked, which land are you fighting for? Is it not for us? I say yes. So there was need, and we started using their knowledge on communication, social media to advise or to let the community know what are the issues going on. So the Constitution of Kenya, of course, the Community Land Act 2016 made a very big impact that we were now able to say, yes, we need community land. And that's what we are fighting for until now. We are still asking, and when we got the ruling, or rather the judgment in 2017, identifying and saying that the Ogiek are the indigenous peoples of Kenya. I think we are the only first community to be declared in the court of law that we are the indigenous peoples of Kenya. And then later on, we got a reparation judgment in 2022, which we were able to underscore all the issues, including restitution, compensation, among many others. But as you might realize, our greatest challenge has been political goodwill, because we have not gotten political goodwill. That's why until today, despite the two judgments, I call them the two judgments, we have not had implementation. And my friends, Emily and Don will tell you, we had even in less than a month ago, we had even a compliance hearing in Arusha, Tanzania, trying to ask the government of Kenya why they have not implemented the Ogiek case. Amidst all this, we kept going and having the community in, creating, and one of the other issues is that even as we do all that, we continue doing restoration of Mau Forest Complex. We continue working and asking, even working with the Kenya Forest Service, trying to say that even as we are fighting for the same Mau, we find a way of restoring the same place. So as we are talking right now, we are still asking, or we are waiting for a roadmap on how the implementation will be done, which maybe the Kenyan government, they ask for time to do all this. And of course, our work with the judges already asked them to give them a roadmap, which maybe they may keep or not. But as we are talking right now, the Ogiek community, which is around 52,000, somebody might ask me that, and how big is Mau? Over 400,000 hectares. All these areas, we are asking that we need to have a way of protecting and restoring, not only for the Ogiek, but for the whole country. And as I finalize, because I'll be very happy to have more questions or question to really clarify many issues, how the journey has been. One great thing is that we had a very strong legal team, including down there, who really helped the OGIEG to move where they have reached, including a lot of research done about the object, because some of them, the government was saying, oh, it is because of the issue of environment. So there's been a conflict of ownership of Mao in terms of who is, are you going to protect? Are you going to do this or that? So that has been one of the issues which we have been struggling with. And we are now asking, or we are still appealing to the Kenyan government to fast track the implementation. Now OGIEG really do other things instead of being in the corridors of law all the time, asking for justice for their land rights. So I know there are many cultural issues which we feel it is also very important that we strengthen our cultural values and protect the Ogiek language and protect our religious not saying that we are anti Christianity or any other religion, is that we need to protect our culture, our religion, and also protect the future and the future of the Ogiek community for now and for future. So I
Thank you
wish
so
to
much.
stop
Thank
there
you so much.
so that you are able to give questions if there are.
Thank you so much. Thank you. Thank you so much. We will be having questions, as I am so sure about my colleagues who are here. Thank you, Mr. Kobe. I will now invite Emily Kinama, and thank you so much, Mr. Kobe, for what you've said about the lawyers who are here with us, who have also helped the OGIEG in their litigation process. So, Emily, my question to you is, what jurisprudential trend do you see in Kenyan courts applying the precautionary principle to climate claims? And of course, based on what Kobe has talked about, were these part of the litigation issues in court? Welcome, Emily.
Thank you very much, Customs, and greetings as well to Kobe and Mr. Dare, who we worked very closely with. I've received a very interesting question that links issues with respect to environmental law, as well as what you called or you've titled in the context of this webinar, third generation rights. I think when we're talking about climate litigation and we are talking about environmental litigation in Kenya, and those are anchored under Article 42 of the Constitution that protects the right to a clean and healthy environment for every person. And from that particular provision, which is very interesting as compared to other rights within the Bill of Rights, the Constitution went a step ahead to provide different provisions other than the ordinary Article 23 of the Constitution in terms of 22 and 23 in terms of people going to court to challenge violation of those rights. For environmental rights, you have other provisions that actually anchor how you would go to court. Very good to see how they framed environmental rights in the context of Article 42, where they look at it in the sense of protection of the environment, not only for this generation, but for the future generation. And that is linked with sustainable development, which is also under Article 10, which is a value, a national value and principle that every person is bound by when they're interpreting the Constitution, the law, and other policies. In addition, it links this protection of environmental rights with Article 69 of the Constitution, which sets forth specific state obligations that the state must follow when protecting the environment and natural resources. Secondly, when we're looking at environmental rights, we look at Article 42B, which says that there are obligations of the environment that must be looked at in the context of Article 70 of the Constitution. Very critical as we now move into climate litigation, because the Constitution saw that this protection of environmental rights is so core and so critical, and that it was not there in the former Constitution, the 1963 Constitution, and put a ring fence and a barrier for protection of these particular rights. If we go to now Article 69, which is linked to Article 42 of the Constitution, you have to read it holistically. I bet by now, if you're in your final year, you've understood the holistic interpretation of the Constitution. Tinyefunza, how you read one provision with the other, with each marrying each other instead of cancelling each other. So essentially, Article 69 of the Constitution has 8 obligations, and 69.1, I would encourage you to go through, read Article 69.1a to h. And then most importantly, Article 69.2 of the Constitution, which not only bounds 69.1 puts state obligations, but 69.2 is very critical because it also puts us an obligation and a duty on every person to cooperate with the state in terms of protection and conservation of the environment, which I have not seen in other provisions of the Constitution. Most obligations are directed towards the state, especially positive obligations, but for private people, it's mostly negative obligations. But in Article 69.2, we see an aspect of a positive obligation put upon every person, both private and public, to ensure they cooperate with the state to protect the environment. Now, the question of climate litigation has evolved over the last couple of years with a number of cases coming before courts. And it's good to give a background. You all remember the Wangari Maathai case, where she went to file a case to try to protect Uhuru Park from being grabbed. That's one of the cases where issues related to standing arose, that she have direct standing to protect Uhuru Park. And so there are other cases that have developed under the new constitution that look at environmental rights, and others that look at climate litigation. If I go to climate litigation, I'll skip environmental rights due to time, and I will go directly to climate litigation. And I will say or direct you all to go try read Article 70 of the Constitution. That is almost similar to Article 22 that puts a standing or 22 read with 23 of the Constitution, where you feel that there's a threat, or there is a threat or an actual violation of the Constitution, and then someone can approach the courts. So in Article 70 is what now Carson has asked in the context of the precautionary principle. And in my opinion, I think Article 73 of the Constitution has crystallized the precautionary principle in the context of environmental rights in Kenya. Of the Constitution says, for purposes of Article 70, which talks about any person approaching a court where their environment and natural resource rights are being violated, they can now come to court. Article 73, if you allow me to read it, says the following. For purposes of this article, an applicant does not have to demonstrate that any person incurred loss or suffered injury before going to court. And that sort of enshrines what the precautionary principles in the context of environmental rights is, which means you do not need to prove there is a loss. And for climate litigation,
Emily, sorry, we lost you for a few seconds. We are having problems with the broken internet. I mean, intermittent network connection. Could you go back like 1 minute? What you were saying? Just 1 minute, or like.
I'll go back to what Article 73, Article 70, sub-Article 3 of the Constitution, which I think, I believe it enshrines the precautionary principle within the Constitution. And it says that for enforcement of environmental rights, that for purposes of this article, an applicant does not have to demonstrate that any person incurred loss or suffered injury before approaching a court to file a case that there is a threat to the violation of the environmental natural resources or there is an actual violation of the environmental resources. And why do I say this enshrines a precautionary principle in the Constitution? This is because when we're dealing with environmental and climate litigation cases, there is usually the defense that there is no science to back that there is a harm, that there is no harm. But the precautionary principle believes or looks at the protection of the environment to the extent that once the environment is damaged, nothing can be done to restore the environment to the state it ought to be at. Case has been filed, then there needs to be a precaution or a step taken by the adjudicative body, be it the Environmental Land Court in Kenya or the National Environment Management Authority, to put a hold to any activities or proposed activities until it has determined a dispute whether there is a threat of the environment. So that essentially is a precautionary principle. So now as we move on to litigation of climate change, there have not been many cases that look at the litigation, climate change litigation directly. Climate change litigation has been defined very broadly to include quite a number of things, but there have been some cases which luckily as Katiba Institute have undertaken, which have protected or looked at climate litigation and the protection of the environment. And I'll mention maybe two cases. One such case is the Save Lamu case, Save Lamu and others versus Amu Power Company and another. And this case essentially challenged the establishment of a 1,050 megawatt coal-fired power plant in Kwasasi area within Lamu, which, as you all know, is a UNESCO World Heritage Site. And part of the challenges, this particular case actually went to the National Environment Tribunal. It challenged the establishment of this coal-fired power plant without there being public participation in other processes such as a climate impact assessment or considerations of climate laws that Kenya has passed and has recognized both domestically and internationally. And those were some of the bases that we raised for of the environmental impact assessment license that was issued to the company. And the court agreed with us that public participation was not taken properly. And secondly, it also stated that for every project that is undertaken in Kenya, especially for such a magnitude, there is a requirement of the project proponent to consider the climate impact, the climate laws within the country, and not just quote them, but holistically see what are the mitigation and the adaptation measures in relation to that, which was not done in this particular case. And the second case that is on appeal, actually it's now on appeal and we are awaiting judgment sometime in September. So take a look out for that case. The second case involved the SG, the President was going to pass two climatic zones between two counties. There was a requirement of a climate impact assessment done before the project, and there was a failure of a climate impact assessment. However, the court did not cancel the project. That is one of the unfortunate cases we look back on. And in the case, one of the recommendations was that a climate impact assessment be done post already the project having been done, which we think is a bit of a challenge. And then on to another constitutional challenge, maybe as I wind up on the issue, the specific issue you've questioned me on the precautionary principle, is a case which we filed sometime back in 2018. The first case, I think, was filed by Okia Omtata. It challenged a very interesting section within the Environment Management and Coordination Act, Section 129.4. This particular provision in MCA, I will refer to the law as we refer to it as MCA, puts the precautionary principle, essentially saying it also legislates a precautionary precautionary principle, and this was there even before the 2010 Constitution. But essentially, it says when someone files a case at the National Environment Tribunal appealing the decision of NEMA, there is an automatic stay, meaning no project should proceed the moment an appeal is filed. And so if there was any project, anything that was going on, they stop it until the National Environment Tribunal makes a determination. And this effectively is a precautionary principle. What then happened? Because at that period of time, around 2018, 2017, there were quite a number of infrastructural projects that were taking place that were not following the environmental impact assessment and ESIA processes and the strategic environmental assessment processes. So there were quite a number of cases being filed with the National Environment Tribunal challenging these projects. And so, of course, understandably so, a lot of the project proponents were trying to remove this provision of the law. And parliamentarians actually agreed with them. And interesting enough, it came to our attention that they tried to amend an environmental law through the Prevention of Torture Act. So how much mischief is there that you go to the Prevention of Torture Act and you are talking about torture in the entire legislation? Then somewhere in the middle there, you enter an amendment to a critical law, the Environmental Management and Coordination Act. So Okia rushed to court, filed and got a conservatory order at the High Court. And then in the same year, in 2018, when that conservatory order was given, Parliament passed another statutory miscellaneous act of 2018, again introducing or reintroducing the same amendment to the MCA. So you can see how hell-bent they were on changing or amending this law. And so in 2025, we received a judgment from the High Court. Justice Muta stated that the amendment to these provisions were unconstitutional and that there is a place within which the precautionary principle and Section 129(4) ought to be done. And it also looked at the mischief behind Parliament using very unrelated laws to amend critical provisions of the Constitution. As we think again, and as I tie to the challenges that communities such as the Ogieku will represent, which are indigenous communities, I would really also encourage you, as we're thinking of climate change impacts, to look at what are the current discourse in the context of climate change and the place of indigenous communities and this role they have played in protection of critical resources such as the Mau forests, which they've done since time immemorial, and how in the context of climate change, they must be part and parcel of this in the context of free, prior, and informed consent and recognizing their tenure rights, which is at the core of a lot of what the indigenous communities have been arguing. And it is also at the core of the Constitution, where they are recognized and their community land rights are recognized under Article 69, 2 and 3, 69 of the Constitution. Thank you very much, Cassie.
Thank you so much, Emily, for your thorough, I would say, answer of that question. I was going to have a follow-up question, but you've answered already on Article 69. Thank you so much, Emily. I will leave the rest of the questions to members of the audience and also people who are listening online. I would also like to recognize Minora Mbagathi, the Executive Director at Katiba Institute, who is joining us online. Thank you so much for joining us, and we look forward to hearing or getting a word from you as well. That is, if you have, or actually, we would love to hear from you. We also have now going to our third panelist so that we can have questions and any other questions that we may have for our panelists. But we have Mr. Donald there, who has been referred to by the first panelist, Mr. Bay, as Emily Kimana. Mr. Dare, at the African Court, collective rights are often framed under Article 22 of the African Charter. how can litigants better evidence customary tenure system to meet admissibility hurdles? You're welcome, sir.
Okay. Thank you very much. I noticed that you have sharpened the question to just focus on meeting admissibility standards that that would be applicable at the African Court on Human and People's Rights. I will answer that specific question, but just allow me to take a few minutes to just touch on a few other things to just set the pace so that people have it in mind when we're speaking. One is that we have these rights. I know you have articulated how these rights are protected at the Kenyan level under the Kenyan Constitution, and I think Emily has done a good job of elaborating on that. But to say that these rights are also protected under the Treaty for the Establishment of the East African Community, the EAC Treaty, from Article 110 to 114 talks about the right to a clean and healthy environment, food security rights, rights over natural resources, and of course the general Article 6 and 7, democracy, good governance, rule of law, and human and people's rights in accordance with the African Charter, which then imports the entire African Charter regime into the East African community. And also to say that in terms of the African Charter and what we call the African human rights system writ large, they're quite elaborate on what are group and solidarity rights from Article 18 to Article 24, rights of family, women, children, rights of persons with disability, rights of peoples to equality and against domination, right to self-determination, right to enjoy wealth and natural resources, right to development, a right to peace and security, and specifically the right to a satisfactory environment. So I think it's important to just have that in at the back of our minds. And then that at the East African Court of Justice itself, we'll end up with the African Court, but at the East African Court of Justice itself, there's been both litigation as well as jurisprudence on the issues we're talking about. Starting with the case, the Serengeti case filed in 2010 and whose decision came out in 2014. That's a case of the African Network for Animal Welfare versus the government of Tanzania. Here, a continental NGO based in Nairobi, represented by a Kenyan lawyer, sued the Tanzanian government when it wanted to build a road, a tarmac road right through the Serengeti National Park, which would have affected the entire Mara Serengeti system. And the East African Court of Justice said, no, it cannot do that. Right now, we do have several cases that we're handling, defending the Maasai of Loliondo and of Ngorongoro, whom the government wants to evict on their land. The real reason is it wants to give up this land to foreign companies for wild game hunting and to build additional hotels. But they're trying to make fake arguments saying that the Maasai are the ones who are affecting the animals and affecting the environment. And we're contesting that. When we go to the continental level, again, what we call the African human rights system has at its core the African Court on Human and People's Rights in Arusha, but it also has the African Commission on Human and People's Rights in Banjul, and it has the African Committee of Experts on the Rights and Welfare of the Child in Maseru, Lesotho, and of course the political organs in Addis Ababa under the AU Commission. So the African Commission, as you know, has a dual mandate to both protect and to promote human and people's rights. So you can undertake litigation at the Commission and come up with decisions which the governments or the member states are then under obligation to implement. So for instance, we had the successful Endorois case way back, filed in 2008. I think the decision came out in 2011 that protected the rights of the Endorois, and it's part of what inspired, as Daniel Kobe has said, inspired the Ogiek community to go to the African Commission and to ask the African Commission to refer the matter to the African Court. So before we go to this litigation you can do, but there's also the special mechanisms, special rapporteurs, working groups and committees of the African Commission, which can move much faster in protecting, making interventions, doing investigations, producing letters, petitions, demands, and also developing the soft law of the Commission, principles, guidelines, general comments, and so on. So of relevance to the topic we're discussing today, we do have the working group on indigenous. The same thing happened. No, sorry. sorry, we do have the working group on indigenous people's rights, indigenous populations and communities, which focuses on the human rights of indigenous peoples and populations. But we also do have the working group on extractive industries, environment, and human rights violations. So that is, important. Coming now to the specific issue of litigation at the African Court and admissibility standards, the challenge we face, as you know, at the African Court is one, can only sue a state that has ratified the protocol establishing the African Court and has also filed or made in a declaration for direct access under Article 34 of the protocol establishing the court. And right now we have only 8 states that have declarations that allow their citizens to come directly to the African court. So for those ones, the only thing they have to do is exhaust local remedies. That means file cases and take it up to the highest court within their state, in our case, the Supreme Court, unless you can prove that the national remedies were not effective for you or were unduly prolonged. But for the rest of the states, and that includes Kenya, the only way you can end up at the African court is if you exhaust local remedies or prove that local remedies were not available for you, then you file a communication to the African Commission on Human and People's Rights, and either the commission itself decides to refer, or you request the commission to refer, and the commission refers the matter to the African court, because organs and institutions of the AU can approach the African court directly. And that is what the Ogiek community did with the NGOs and actors that were supporting them. They filed the complaint at the African Commission on Human and People's Rights, and they asked the commission to please refer the case to the court. That means when it comes to the court, the real litigant or the formal litigant is the commission. And the community is just taken as the original complainant. But that is exactly what has happened in the case of the Ogiek. And when the African Commission wanted to refer the case, because they had not done a lot of litigation as a litigant at the court. They had run their own tribunal in Banjul, but they had not been litigators somewhere else. So that's when they requested Palu and a few other lawyers to represent them pro bono, to join the team from the national level that was already supporting the Ogiek, and to represent them at the African court. And that's what we have done. And eventually, over time, gotten a strong decision on the merits. We can unpack it later. A very strong decision on reparations, which the government has not been implemented. And most recently, we've held hearings on compliance to try and see to what extent the government of Kenya has implemented the strong decisions on merits and on reparations. And we are hoping that the court will express itself soon in the course of the next few weeks on what it feels about the lack of compliance by the government of Kenya. Maybe I should stop there for now, Kasam. Thank you.
Thank you so much. Thank you so much. You are very right on time, and you still have 2 minutes, but I will see how you will get those 2 minutes by asking you a direct question from my table. Would Pan-African advisory opinion on laws and damage strengthen national climate litigation? I'm just tweaking instead of Emily, who answered a follow-up question that I had based on what you've said. Also, to add on that as well, we see that nowadays people at the Ogiek, and I'm sure Ogiek will talk, is there is price on product digitals here.
I think we are not getting Kasam.
Yes, I think they have serious internet challenges.
Sorry, we can hear you.
Yeah, but you broke up so much, so we didn't even hear what your question was.
My apologies. I am going to repeat.
Yeah.
About I'm gonna have to turn this off. Sorry. With an African advisory opinion on laws and damages during the national climate litigation. I know you didn't talk about climate change, but the reason why I'm tying this to climate change is that what what the indigenous peoples took to the court in the regional uh, courts is that there were issues of that generational rights, as you have rightly elaborated on cultural rights, such as bicultural rights. So I wanted to ask you about that issue of advisory opinion on loss and damage. As a way to strengthen the national climate litigation? And also, what do you think about the bicultural protocols that organic people and others like the Endorais have put down? Yeah, thank you.
Thank you very much, Carson. And I think it is good that you brought the question now, because I think it links to the earlier question that you asked about litigation generally at the African court and the admissibility issue. So, of course, two types of litigation can happen at the African court. One could be a complaint against a state or a group of states, which we have addressed before, whereby if there are Article 34(6) states, you can sue them directly. If not, your best shot is to go to the African Commission and ask the Commission to refer, and the Commission refers. So that's contentious litigation. But there's also non-contentious litigation, which is the advisory jurisdiction of the court, that one can request an advisory opinion from the court, and then the court can render an advisory opinion. Now, the advisory opinion can be requested by a member state or a group of member states. It can be requested by AU organs or institutions. That's like the Banjul Commission or the Office of the Legal Counsel or the Commission of International. They can request if they're organs, or an African organization recognized by the AU, meaning even civil society, if recognized by the AU, can request for an advisory opinion. And the court, in terms of locus standi, has ruled very conservatively that it must be an organization that has observer status with the AU in Addis, or that has a memorandum of understanding with the AU in Addis. Now, PALU does have such an MOU, a very wide-ranging MOU, signed way back in 2006 with the AU. So we're one of the very few organizations that we know of currently in civil society that can request advisory opinions. And it's not theoretical. 2 months ago, we actually requested an advisory opinion on around climate change and human rights. On climate change and human rights. So the long and short of it is it's going to be processed, and we can unpack it later if you want, because we're really encouraging lots of African actors and friends of Africa to look at how to participate in this request for advisory opinion on the obligation of states in the context of climate change, either as experts, expert witnesses, interveners, amici curiae, and so on, or co-litigants. So once the court renders its advisory opinion, under the principle of pacta sunt servanda, the states are obliged to abide by it, adhere to it, and ensure compliance with it. And one of the best ways, not the only one of the best ways of that happening is colleagues who litigate at the national level using this jurisprudence to anchor litigation that they're doing at the national level, so that this is then integrated into national court decision making. So we really encourage our colleagues to look out for the jurisprudence when it comes, and we see how, among other ways, we can strengthen it through courts. But the same thing, you can make decisions to parliament. and get Parliament to use that to change laws and to change policies at the national level. Thank you.
Thank you so much. Thank you. Thank you very much. I will now give opportunity to members of the audience here. As well as those who are online. We have technical team who are here, who can help us with that. Maybe we can start with the members who are seated in the hall.
Rate more on the aspect of carbon trading in terms of, as much as we are saying that we have rights on protection of the environment, I think Miss Emily touched on the fact that the project proponents should also consider the laws that govern the country itself. And in that way, I would like you guys, the panelists, to clarify on the aspect of free, prior, and informed consent, and can it also be used in Kenya? And in terms of that, what amounts to consent? Because what I know over the past cases that starting with Osman, the Osman case, the Ogiek case, the Ndorois case, which I think so they are also affiliated to now some of these carbon trading projects. So, and whose consent constitutes community consent? So that's my question, rather. Thank you.
Thank you very much, Marcy. Another question I see there. Also, Stan, maybe you can let us know the questions that are from the online participants. Thank you.
Good afternoon. My name is Kipego Emmanuel, and my question would be directed to Miss Emily. And starting off, a brief part of my question is that the Constitution provides for the three categorization of lands: the community, the public, and the private land. These community lands, one, on the unregistered community lands, the county government holds this land in trust on the community. Secondly, that the registered lands and registered community lands in Kenya, which there's been a problem in terms of registration of these community land rights, and or on other cases, disposal of such community land rights, which at times requires the major impact from the community members. Now, my question would be directed to Emily for this reason that her introduction was that she majors on urban and physical planning laws. And the question would be, how can urban planning frameworks and our sectional properties laws in Kenya be reformed to balance the recognition of community land rights, such as those of the indigenous groups like the Ogiek, noting that there is a growing demand for individualized property ownership and urban developments in Kenya. This and how can they be merged to actually ensure equitable access to land and sustainable urban growth. Noting that everyone has to have a decision and a collective responsibility to such land. Thank you so much.
Thank you, Emmanuel. Do we have any more questions from? All right, so maybe we can answer those two questions first. Emily, you have your question already. Who would like to take the first question?
I think Mr. Kobe can start with FPIC, and then I can maybe add on. As a community, they've really engaged deeply on matters FPIC, and then I can the others as they follow.
When we talk of Libra informed consent, first is you say who will give. It is the community to agree to give or not to give consent. For instance, amongst the OGA, we came up with FPIC protocol. That protocol, we documented it, which will give us whether we want this particular project to take place in our land and territories or not. If it is going to, if we agree to it to take place within our setup, then we have to give conditions or requirements. And the OGA Council of Elders play a critical role in most of the issues which are taking place within the OGA land or among other indigenous communities. I think in Africa, we have very few communities who have come up with the FPIC protocol, and even globally, because it is a document which very few people, because it's anchored under UN, which I know most of you now are aware about that, being students of law. And we have also come up with what you call a bicultural protocol. Bicultural protocol mostly was dealing with bio, of course, those which are, because we realized our many researchers, pharmaceuticals, and many organizations trying to do research within our land, and they just pick anybody amongst the community for their research or whatever work they want to do. I think the enterprise have a very good example. I'm sure customers have discussed with you sometimes of the situation in Lake Bogoria. So the situation about FPIC or bicultural protocol is within the community, because these are rules which you set up as a community yourself. But you always wish also to be entrenched within the constitution or within the setup of your country or your counties, so that they are aware about what is happening. I think we could share a lot about, because that's another full discussion about the protocols and how they are used within the communities. Thank you.
Thank you so much, Mr. Kobe. I just wanted to let everyone know that Mr. Donald there has left, but we have in his place able colleague from the organization who is also an advocate, Esther Wanjiru Muigai. So welcome. Thank you, Mr. Kobe, for your answer on FPIC. Maybe just a follow-up so that you can answer in less than 20 seconds. Mercy had asked what amounts to consent, and in terms of representation to the entire community. And my apologies today, I may not answer that question, even though I would answer in class. But you are here and you have that knowledge. Thank you. So the question is, what amounts to consent? If I'm amounts to community consent. I know you've talked about Ogier Council of Elders. Does that amount to the community consent?
by the formation of a council of elders, I mean it is representative to the community. They are being given the powers by the community, because you can imagine it is like public participation. I know in Kenya we have the public participation, and many times we ask who participated, because it may not be all of us, but somehow public participation were done in some quarters, but it may not be 100%. Even within the community, we have leaders. We have people who are leaders from various clans and such like. So those are the ones which will speak on behalf. But of course, they don't just speak without getting technical support or from professionals, from skilled people. Like in some time when we were doing something on historical land injustice, HLIs, we had to bring on board some of our legal team, which included even Emily and many others, so that they can advise the community, so that you don't make decision or you don't make mistakes in handling any agenda or any issue within the community. So that's also what FPIC does. Thank you.
Thank you very much. Now, Emily, would you like to answer that question from Emmanuel?
Okay, thank you for that. I wanted to add just a bit on what Mr. Kobe has said. It's a question that the issue of FPICA is a question that has been raised before our courts, but none of the parties who've raised questions of FPICA have actually reached the level of being maybe described as indigenous. That's where most of the cases in Kenya have fallen on. But when we discuss free, prior, and informed consent, free meaning is it given without coercion? Prior meaning is it given way in advance? Are you called for a meeting one day before? You have no idea what the meeting is about, and you're called for the meeting and you're told to make decisions. Is there an instance where it's the government that chooses one particular case representing the OGEC? It's the government who chose who are the representatives of the community that they wanted in the meeting. Is it informed consent? Have they been given prior information about the meeting? Do they know the decisions that they're making and the impact of their decision? And when you say who exactly is making that decision, have you allowed the community representatives? Because if we're talking about 30,000 people, have you allowed the community representatives that the community themselves have chosen to then go back to the community and inform them of what exactly consent that they're supposed to give? So it's an entire chain of process, and it's not a one-day event. But unfortunately, the state and some project proponents take it as a one-day event where you tick the box in terms of ordinary public participation, yet it ought not to be that way. So it's very critical to look at those aspects of free, prior, and informed consent, even in the international space. If you look at mutual welfare, it says where there are instances of a gap in the law, you can look at general comments. And in Kenya, Kenya has ratified critical documents that discuss or bring to the fore free, prior, and informed consent when you're looking at cultural rights and other rights internationally. Free, prior, and informed consent of the community. So which is the community? Tell the representatives, if it's representatives, allow them time to go back to the community, and then come back and give the information, consent or otherwise, by the community. And it means saying no. It means actually saying no, we do not want to proceed with this that is what consent is, yes or no. And then into the second question on both community, public and private land, I agree with you, Emmanuel. There are a lot of issues that are arising in terms of unregistered community land that is held in trust by the county government, but there's been very progressive judgments that have been given by our courts. One such case is Peter Kitando, where land had been transferred for the Mount Elgon Ogiek. It was being held in trust by the county government of Bungoma, but they transferred the land without including the community. And in such an instance, such a transfer was declared as unconstitutional, contrary to both the constitution as the then constitution, the 1963 constitution, and the Trust Land Act. Another second case, we should look at the three-judge bench from the Marsabit decision, where over 10,000 acres of land was transferred in the name of it was a windmill company, I think from Europe, that had come of Marsabit Mandera, I'm not sure, had given away the land, which they were holding in trust on behalf of the community. And a three-judge bench said the process was not followed and that was unconstitutional. So as much as it is unregistered community land, there are protections in the law to ensure that communities are included within these processes and that, in fact, government acts as that person that protects it. On the issue of whether urban laws can be used to govern community lands, I choose a very different aspect. When we're looking at informal settlement land, most of the land is either private or public. It is already determined in terms of the urban settlements. However, when we talk of community land, we're talking of unregistered community land. Communities are going through the processes of registering the land under the 2016 Community Land Act and the Article 69 of the Constitution that recognizes what community lands are. Therefore, I believe that the law has to look differently when we're talking about community lands. There's a case that has been challenged by Haki na Sharia and others, which essentially challenges, for example, a big problem we are facing with unregistered community land, where they're now doing compulsory acquisition and valuing community land at the same level as urban land. A big piece of land for pastoralist communities in Marsabit or northern Kenya, where they do not perhaps build houses in the ordinary sense of valuation, cannot be treated the same way or equally to urban land where you've built a structure and it is valued according to urban valuation practices, and you're given compensation for that. So this is a whole issue that is arising, and we're seeing arising in the context of huge infrastructural projects like the SGR, the road connecting the LAPSET projects in Isiolo and these areas where there's a lot of unregistered community land. And essentially this case is challenging provisions of the Land Amendment Valuation Act that essentially does not look at challenges or the dynamics and the demographics of unregistered or community land, where the use of community land is tied to their cultural aspects. If you go to Mau Forest, you might not find they've built trees within, or they've built huge structures, or whatever the case may be, where they're protecting the environment. But does that mean you do not value that land and look at external costs or other issues the same way as communities? So that case is before the Environment and Land Court in Nairobi, and we are an interested party, and we hope, we're waiting to see the experts who've tendered evidence on how valuation systems in the context of community land has evolved. So that is an area we're looking at. So my question to you is no, to look differently at the different types and typologies of land, and that there's a specific protection given to community land, and including unregistered community land. So the responsibility is on us to ensure that those lands are protected for the communities, and we are able to move the processes faster to ensure that they secure their tenure even more through the registration of these community lands. Thank you.
Thank you very much, Emily. I believe Emmanuel's question has been answered well, and also Mercy's. We do have two more questions, and then we can wrap up. Was it one or two? One. Yeah, please.
Good afternoon. My name is Mirabel Rotich, and I have one question to all the panelists. So when all is said and done, what reforms, or what do you think would be the solution that would encompass and take care of the interests of the government, that is the economic aspect, protects the community rights, and also the safeguarding the environment? Thank you.
Thank you very much, Emily. Who would like to pick that question? For now, we do have Esther Mnaro and Mr. Kobe and Emily Kinawa. Yeah, who can take that question?
So okay. Maybe oh, sorry. Yes, Shiro. Go
you
ahead.
Can go first. Just go first.
I think Yes, thank you, Shiro. For my perspective is three key things. The Constitution and the law already puts the structures and the procedures that ought to be followed when we are balancing infrastructural and economic aspects as well as rights. There are environmental impact assessment, strategic environmental assessments that need to be done. But the problem we're always facing is the implementation of the laws. Follow the laws as they are. And following the laws actually means in some instances that there's a no option. You do not need, for example, to pass a road in the middle of a national park. There is another cheaper option that can be found to attain your means of getting the road and also respecting and protecting the environment as an example. Secondly, obedience of court orders. Obedience of court orders is very critical. From the regional level with the decision of the African Court, there is no obedience by the state of Kenya in the sense of the African Court determinations, both the merits judgment of 2017 as well as the reparations judgment of 2023. If there was even an ounce of even one order of that court, like publication of the judgment in newspapers of national circulation, at least you're showing hope, or that you're showing that there's a need, or that the state is actually considering in obeying these court orders. And then finally, you cannot wish away communities, indigenous communities that have lived with us since time immemorial. The record speaks for it. And I'll repeat what the late Feroz Noji said in terms of the work we do and filing of these cases, and why you see Kobe in court for more than 30 years and his community and other communities. It's for the records. Since 1920s or whatever the case may be, a lot of these land records that I have read and I have looked at, indigenous communities kept going before the governments or the states from pre-colonial era, colonial era, and after, saying that you need to protect their land rights and that they exist and they're there. You cannot wish them away because they're a minority. And finally, protect their community land tenure. It is possible to protect their community land tenure. It is possible for communities to be owners and conservators of their land, if it's forests or national parks or conservation areas. They've been doing this since time immemorial. So I think that's what I would say. Thank you.
Mr. Kobe, before we leave, I will give you opportunity, Ms. Mnaro, to say something. I know you had opened up your mic, but Mr. Kobe, before you leave, we are closing in the next maybe 5 minutes. If you are rushing, still we can give you opportunity to wrap up. I see Ms. Mnaro's comment. She says that Ms. Kinama has said everything and she wouldn't have any comment. Mr. Kobe, would you like to close with one last comment, or if it's okay, I will pass on to the next section, which is closing. Okay, so I don't know if would you like to say something, Mr. Kobe? Probably Mr. Kobe has left, but so we have our coordinator, Ruth Chebet, who will give a vote of thanks, and then we can end. But before that, I would like to thank you all. I would like to thank our esteemed panelists, Mr. Dare, Ms. Kinama, and Mr. Kobe, and now on behalf of Mr. Dare, Ms. Mnaro, also members of the in-person audience at Sawia Auditorium at Kabarak Law School. I would like also to thank members of the faculty, Ms. Melissa Mungai and Mr. Kadima, and Stanley Mayaka and Lauren Nyamo. Thank you, everyone. My classmates who are here and everyone else seated in the members of the audience. I would like to thank you so much for your time and the questions. We are all grateful as members of Avid Readers Forum of Kabarak Law School. Ruth Chebet, would you like to close with a vote of thanks and prayer, maybe? Yes. Oh, Ruth is asking me to still throw it back to members of the panelists to just say, like just a closing statement. Emily or Miss Mnaro, do you have a closing statement?
It's just to say that I know sometimes it does look like it's all dull, especially when we have good judgments and they're not being implemented right from national level to regional level. But that should never kill our spirit to keep pushing. Either way, at one point, those judgments, there are some leaders that see the essence of them and they implement. So we have to keep litigating and we have to keep advocating. There are people that actually do respect good judgments. And if we don't speak up, then who will? So it's just to keep at it.
Thank you very much. Emily?
I'll just repeat, obedience of the Constitution is very key, and that there's a reason why there is constitutional supremacy. So obedience of the Constitution by every person, both state and non-state actors, is very key in realizing these collective rights.
Thank you. Thank you very much. Thank you both for giving us your important time, your valuable time. We know you had a lot of work going on, but you were here discussing and helping us unpack the third generation rights at Katiba at 15. And I will now welcome Ruth Chebet to pass a vote of thanks.
Good evening, good Hassan, can you hear me?
Yes, we can hear you.
Thank you so much. Allow me not to open my camera. I just wanted to say the vote of thanks, and first of all to our esteemed panelist, Miss Emily Kinama, Mr. Donald Dare, and Mr. Kobe in their absence. We are just so grateful for your attendance. I don't think we've had such an insightful discussion on Indigenous people's rights, and to have this opportunity to listen to you has been really amazing. And we'd like to thank you so much for your time. We know you have a busy schedule, but thank you so much for honoring our invitation. Also received greetings from the convener, Mr. Elisha Ongoya. He was not able to be here today, but he sends his greetings. Also my co-coordinator, Mr. Cedric Kadima, and our dean, Professor John Rosagoambani. So apart from the panelists, I also like to thank all students who were able to show up today to listen to this insightful conversation, especially the ones who have been with us since the first series. We see the way you honor your interest to acquire knowledge. As you might know, our motto as the Avid Readers Forum is acquisition of knowledge is our pride. Therefore, thank you so much for joining us for all the 3 weeks. As you know, we are undergoing a very depressing season as a country right now. So to be able to have conversations about the rights and the legacy of the 2010 Constitution has been such an honor, but we could not have done it without you. So thank you so much to all who have been joining us, and particularly those who have joined us today. And also like to say thank you to the ones in the background. Thank you to the media team. Thank you to Stanley and the team. Also, thank you to Nyamu, Lorraine Nyamu, and Mr. Humphrey Simpala, our teacher, who has shown such a collaborative spirit. They're not in the Avid Readers Forum, but they have been so instrumental in making this happen, yet they're in the press. So thank you to them. And also thank you to my co-coordinator and our dear moderator for the wonderful job done. And I think I will end it at that and just say karibuni and welcome to next week's session.
Thank you so much. Thank you, Ruth. We started with prayer and we will end with prayer. I will ask Loco once again to close with prayer. And thank you, everyone. You wait for the prayer and then we will shut it down.
Let's pray. Everlasting Father, Lord of Lords, King of Kings, we bow before your presence once again. Thank you because of this far you've brought us, O King of Glory. Thank you for the knowledge acquired. Thank you for the discussion. And thank you for the take-homes of God. And we thank you for everything. We continue praying for our lead discussants, that you continue being there for them, protecting them, and being the pillar to hold their lives. I also pray for everyone who joined, that you continue protecting them. The remaining part of the day, we dedicate it to you. We pray that you're going to be there for us as well. In thy name, I do pray this, trusting and believing. Amen.